Welcome to the Ex Terra Podcast. The Ex Terra mission is to explore and discuss the business of space and its effect on the national and global economy, as well as life on Earth. How does what happens in space affect your life every day? That's what we're exploring on the Ex Terra website, as well as on this podcast. My guest is Michael Listner, founder of Space Law and Policy Solutions. And Michael, welcome to the program.
Thank you for having me.
Let's start out with some of the basics. What is the basics of space law and how is it enforced, if it is at all?
Well, space law basically started customarily in 1957 when the Soviets launched Sputnik 1. We created by launching that satellite into orbit and overpassing the territory of other nations, other states, they basically solidified this idea of free access to outer space in what we call customary international law. But as space started to become more prolific, the countries got together, and the U.S. in particular, Eisenhower decided, you know what, we need a new treaty to basically, solidify some of these principles of outer space into, an actual treaty like the Antarctic Treaty, which the Outer Space Treaty is really loosely based on. So back in 1969, they signed 1967, a bunch of states got together, they signed the Outer Space Treaty, which is considered the foundational document for outer space. Now, it's the Outer Space Treaty, depending on who you talk to, people say, well, this is the binding, central authority for all space law. And what I tell people is like, no, if you really read the Outer Space Treaty and if you look at the negotiations that went on, the idea of the Outer Space Treaty is to kind of bring the states together to get some agreement on how to use space, how to utilize space, but it also respects state sovereignty. In other words, the UN has no what we call sovereign authority or authority to dictate or authority to enforce these principles. That is basically left up to the states and their own political will to basically what I really call is voluntary compliance. And this kind of gets into the whole spectrum of international law in itself, because international law is, well, depending on who you talk to, myself included, I don't think it's really what you could call law, because it really lacks the ability to have an enforcement mechanism. It's more political. It's more, we agree we're going to abide by these principles the way we interpret them. And of course, the way these principles are interpreted is based on state interest, on, what is in my national interest on how to interpret this. And this has gone along for a long time, but however, we've seen a shifting of how, law is made in outer space to what we call domestic laws or state laws. And that really started with the in 1984 with the Commercial Space Launch Act, which the Reagan administration actually encouraged, which gives these private non-government, what I call non-governmentals, the authority, the ability to go out and perform space. Now, this idea of performing commercial space is actually in the Outer Space Treaty. It tells states, okay, you can let your private citizens perform space activities, but you got to authorize and continually supervise them. And those words are probably the most powerful words when it comes to commercial space, and the one to evoke the most concern and fear in space operators.
With the fast pace of technology, the way it's moving forward, and all of the strides made in space commerce, has the law kept up?
No, there are really two thoughts on how this should work. There's one thought saying we got to make all these rules and regulations ahead of time, so it'll be in place. So kind of like putting in a highway, a large super highways. Even though I may have a rural proper population with cars, you may not actually use all that bandwidth or all that regulatory authority. But the other side, the side that I prescribe most to, is saying, look, space law is always going to be a little bit behind. That way, you're not dictating to technology and commerce how it should develop. In other words, you're not putting commerce in a box. You're letting it go. You're letting it go and do its thing. And then when appropriate, come in and say, look, we got to pull back on this. We're going to put a little bit of regulation on you because we think it's necessary. So those are those two groups that are consistently, arguing with each other or in competition with each other. And it's all really, I hate to say it's a matter of philosophy, but I guess it's the best term I can come up with right now.
So it sounds like what you're saying is that, like a lot of the law, it's reactionary as opposed to being proactive. Somebody says there ought to be a law, and
it's a matter about there ought to. Yeah, it's one of those things where there ought to be a law, but again, space activities are still so much in their infancy right now. We really don't know how things are going to play out. And to say, well, I'm going to regulate this in advance, really says you can foresee in the future how this is going to work out. And really what we've seen in industry and in a Western free democracy or capitalist society is that industry does take twists and turns, and you can't really accurately map out ahead of time where it's going to go. You can think, well, I might see, this might be the way it does, and create a broad set of guidelines, but it's really difficult to say, I'm going to put these number of restrictions in, and you're just going to have to comply with them whether you want to or not.
Give us a little bit about your background.
Graduated law school, wow, almost 21, 22 years ago. Was very interested in international law. My first paper, my paper in international law was on this topic of space law. It fed an interest, a lifelong interest into space. It really got me an A in international law, and it actually got me published for the first time as a law student. And from there, I just basically started taking up, watching things, just, making my own, just thinking about it a lot. And there was really a long train of thought from, say, 2001 when I graduated, all the way up to 2011 when I really started this company. I started really writing about this in earnest. So, I mean, it's been a long process. I'm still thinking about it. And actually, I think about this every day. And people say, well, how can you think about it every day? Well, I do. I get up in the morning and I think about it. And you know what? I've changed my mind a lot on things because, well, geopolitics change, the world changes, and the world evolves. And I think with that, my thoughts evolve as well. So I'm not really hard set into say, well, this is the way it's got to be. It's a matter of, you got to watch and see. And I like to think, well, I got a brain, I use it and I think about it, and thinking about these every day, I'm always coming up with new nuances. So yeah, I'm very involved into this. It's a big part of my life. It's becoming a bigger part of my legal practice right now. And I think it's really the wave of the future, and I'm really pleased to be able to, become, well, some people call a pioneer. I would think that's not a good term, but basically somebody who's actually creating new ideas and trying, pointing the direction to go in.
When you talk about the regulations and such, and I'm wondering if the realm of space law goes as far as working with organizations like the FAA when they're doing the environmental assessments in Boca Chica and those kinds of things. Is that part of what it is that you do, or are you more focused on satellites in orbit?
I'm more focused on what happens when you get out when you get out of the atmosphere and get into orbit and get into space. We won't get into the whole thing where space begins. That's a big can of worms that would go beyond. We could talk 2 hours on that alone. But I focus more on what happens when we get into space as opposed to when we are on space. But of course, I do think about these ideas with the FAA, with the licensing process. You got to think about what happens when you're in the atmosphere and when you re-enter the atmosphere as well. So yeah, that's a little bit of my thought. That's a little bit of my thought process as well. And I got to consider environmental, which is a big part of when the rocket's actually on the launch pad. I got to think of, the other nuances, the politics involved in it as well. So, we talk about space law, and people put it aside as this one big area that stands by itself, but really it merges with a lot of other areas of law, even more so now that's becoming more prolific in the commercial sector.
With the Russians threatening to pull out of the ISS and then rising tensions with China as well, can space law be upheld amongst all of our nations? Well,
I think it's space law for the most part is an international creature, and there is this idea in enforcement and whether or not a state thinks it's in their national interest to follow a precept or based on what their interpretation of it is. And I'm going to use a terrestrial example just to explain this in a sense, and that comes with the People's Republic of China in the 9-dash line area of the South China Sea. Now, the PRC is a signatory to the UN Convention on the Law of the Sea, UNCLOS. And one of the things UNCLOS says, you shall not claim sovereign territory in the middle of the ocean. That's roughly what it says. The PRC has basically, in my opinion, ignored that and is actually trying to change this to what I mentioned before as customary international law. The same thing with outer space. We have these principles. However, as things start becoming more prolific and there's more competition between the U.S., the PRC, and the Russian Federation, for example, these laws are going to change through, I think, through customary international law. We have these things called the Artemis Accords, which were promulgated back in 2020, which I think we're at 18 signatories right now. They provide guidelines. They kind of provide an outline of what future space rules of the road, guidelines, et cetera, will be based on, but they're not really hard and fast rules in a sense, because again, we're not there yet. So do I expect competition? Yes. We literally are in a great power competition with the PRC and the Russian Federation, and they have a different worldview of what the world should look like, what the rules should be. So as time moves on, we will see pushback on whose view of the rule of law actually prevails in outer space.
You commented on a post on our website that was titled "On Orbit Satellite Fuel Sale Agreement Signed," and you were critical of the deal between Astroscale and Orbit Fab. What were you critical about?
Critical is probably a harsh word, questioning it. Just for the simple fact that under this idea of Article 6 that I talked about in the Outer Space Treaty, non-governmentals, private entities are allowed to perform space activities, but they have to be authorized and supervised by their government. So part of that authorization under our form of government requires Congress to actually write legislation saying to the FAA, we permit you to authorize these types of space activities. Now, right now, the only authorization the FAA really has is to authorize these space tourism flights and commercial satellite launches. There isn't specific authorization for, say, fuel stations in outer space or space debris removal. Congress hasn't authorized that yet. Now, there are exceptions. For example, Northrop Grumman has been testing their rendezvous and proximity spacecraft. They have 2 of them right now performing functions in the geo belt with Intelsat satellites, and they really had to do a lot of bureaucratic twister in order for the FAA to say, okay, we can authorize it, because they don't have specific authorization from Congress. Now, there was a Supreme Court decision called West Virginia versus EPA that came down back at the end of, I think it was June. And basically that reinforced the idea that, look, federal agencies don't have the authority to create regulations outside of the scope of the authority that Congress gives them. In other words, Congress has to tell the agency, you are authorized to regulate these types of activities in this way. So go and do it. And it's the whole idea of separation of powers, that Congress has to legislate it first before the federal agencies can actually regulate it and or license it.
We're talking with Michael Listner, founder of Space Law and Policy, on the Ex Terra Podcast. Take a moment right now and click on subscribe to be sure you don't miss any of our podcasts, or if you're watching on YouTube, any of the videos from Ex Terra, the Journal of Space Commerce. Michael, is contract law valid, necessary, and enforceable when it comes to space activities?
Well, sure. Contract is merging with space law. Well, say I want to launch a satellite, I can not only do I have to get a license from. Well, let's use an example. I'm going to launch a communication satellite. So because communication spectrum is going to be the primary use of that, I'm going to have to go to the FCC first, and I'm going to have to get a license from them. And they're going to make me, talk about what frequencies I'm going to use, and they're also going to talk to me how I'm going to mitigate a dead spacecraft. In other words, when it gets to the end of life, how am I going to deal with that so it doesn't clutter up that geo slot? And those are very, very sparse slots. And then I'm going to have to, of course, get the FAA and get a launch license. And of course, if I'm going to put a camera on there, I'm going to have to go to NOAA and get permission to, take pictures of the Earth. However, outside of that, I'm going to have to build a satellite, which is through a commercial company, which requires a contract to sign with a satellite manufacturer. I'm going to have it launched. So I'm going to go to one of the launch providers, and I'm going to have to get a launch contract with them and pay for that. And then I'm going to have to get other permits and things like that. And I have to contract maybe with other vendors to actually provide support for actually, getting this spacecraft from point A to the launch site in order to put on top of the rocket and launch. And of course, I'm going to have to sign a lease with the launch center, which may be, for example, down at Cape Canaveral, that is under the purview of the Space Force. So I'm going to have an agreement with them as well to launch from their facility. So contract law becomes part of space law, even more so in the sense of commercial actors, because contracts are basically the lifeblood of commercial activities throughout the U.S. and throughout the world. more even in the government, there are contracts. Of course, you got to do it the government's way because that's the way the government likes to do things.
You said something very interesting that I was not aware of, and that is you have to get permission from NOAA to take pictures of the Earth from a satellite. Wouldn't the Earth be in public domain?
Well, it's its whole idea of remote sensing is under the purview the National Oceanographic and Atmospheric Administration, and basically they said if you're ever going to put a camera on a spacecraft and you're going to go into orbit, and there's even a remote chance that you're going to go that the Earth will be captured in that, you need to get our okay first. There was a hullabaloo a few years ago. SpaceX was going to do a launch, and they had a rocket cam on there, but they had to shut it down because NOAA caught up and said, "Oh, wait a minute. Nobody talked to us about this license because that rocket's going to kind of get above the atmosphere and you're going to see the curvature of the Earth." But, SpaceX didn't get a license for it. So they had to shut down that particular rocket cam. And now they have to get a NOAA and get a license every time they want to do a rocket cam. And this goes for ULA as well, if they want to for their rocket cams as well.
Does ESA and other international launch providers or other countries have similar laws where you have to go to a government authority if you want to take pictures of the Earth and engage in Earth observation? Yeah,
pretty much. For example, if you're a U.S. company, you want to launch on a European provider, for example, Arianespace or an Ariane rocket, you're probably going to have. It's going to depend whether or not you're going to launch under their jurisdiction or not. For example, I'm going to build a satellite, but I'm going to contract with a European country to actually build it and launch it. I'm going to launch it under their jurisdiction. In other words, they're going to be what we call a launching state. So I'm going to have to jump through all their hoops. And if I'm going to put a camera on my satellite launched under their jurisdiction, I'm going to have to get their permission. But also, because I'm a U.S. citizen, I might have to come to NOAA too and say, look, I'm going to do this. We're going to need your permission as well. It's what we call kind of a long Article 6 has a long arm statute. In other words, if I'm a citizen of the U.S. but I'm going to another state like Europe or New Zealand. New Zealand's a good example because there is a U.S. company launching out of New Zealand. Mm-hmm. If I'm going to do that, I need the permission and the blessing of the FAA, NOAA, maybe some cases the FCC in order to launch there, and I need New Zealand's blessing as well.
What do governments need to do to create a legal framework for space commerce to flourish?
Well, again, depending who you talk to, I mean, in my opinion, it's got to be, you got to come in, you've got to offer incentives for, a favorable economic environment. You've definitely got to offer a favorable regulatory environment. In other words, am I going to need a room full of lawyers in order to process all the paperwork in order to get a launch? Or am I going to have to maybe staff of 4 or 5 lawyers to process, the paperwork to get the same result? That's a big consideration. And actually, it's one that the commercial industry has been very critical about, saying that, we're really concerned about the U.S. system getting too complicated because, well, there are other states we could go to that are going to be less burdensome for us to actually launch from. So that's that's a huge consideration right there. Another one is geopolitical. Geopolitical. I mean, bottom line is, when you launch from another country, you are under the protection of their state. It's kind of like flagging a ship. Mm-hmm. You're under their protection. And the question is, if something happens up in space between your satellite and the satellite belonging to another country, the question is, are you going to project your political influence to protect my activities, or are you going to throw me under the bus? Or do you have the political strength or what I call the political juice to actually, project influence to actually protect my activities in outer space as well?
How big of an impediment is that to smaller startup companies that want to get engaged in things like Earth observation and getting satellites in orbit with so many CubeSats and microsats and all this communication that's going on? How do they navigate that legal framework?
By hiring lawyers that are experienced in it. I mean, you look at companies like SpaceX and ULA, and they have huge staffs of attorneys that specialize and just focus right on this. There was I think it was SPD2 that was promulgated during the last administration, which basically told the FAA, you need to streamline the licensing process. Well, they did it. In my opinion, they really didn't go far enough. I was more say, you should throw it all away and just start from scratch. But they basically took a lot of comments from the commercial space industry and tried to streamline it. it's still very burdensome in the sense of, you still need a lot, still need a lot of lawyers to actually, get through the paperwork and jump through all the hoops. Now, there are other states like New Zealand, which are just starting off in the space, and their hurdles from as far as bureaucracy goes is a little less than, say, the United States. So in some cases, they may be favorable. There are other states like the United Arab Emirates who have their own domestic space law, and they are in the process of actually promulgating regulations for commercial space launch as well. Now, depending on how burdensome or how unburdensome their laws are, or their regulations are, they may be very attractive and actually take business from potential business, or how can you say, take industry or encourage industry to come over to them as opposed to launching under the auspices of the United States. So, I mean, it all depends on what the government wants to, what a government wants to do in terms of making the regulations difficult, whether it be light touch or very burdensome. And again, the Outer Space Treaty doesn't tell states this is how you're going to regulate them. It basically says, okay, you have the ability to authorize and supervise. We'll leave it up to you how to figure out how to do it. We don't care. And that gets back to the idea that the Outer Space Treaty isn't about creating a central authority. It's about basically setting principles and allowing the states to do their thing.
We haven't talked about this, but as you look forward into exploration of the moon and then at some point Mars, they hope, what are the legal issues that are being discussed now about different countries colonizing other bodies, colonizing the moon?
Yeah, well, the whole issue of colonization, is probably a bad word anyways. And I shy away from, just because the colonial times just have, leave people with a bad taste in their mouth.
I'll give you that.
Centuries of that. Settlement, one of the words we try and use more often is settlement. Again, I'm not trying to be political here as much as, trying to nuance new words in. But the idea of settlement, even settlement, I mean, I see this a lot with a lot of non-governmental organizations promote the idea of space settlement. The Outer Space Treaty really didn't address them. They weren't really, when they built it, they really weren't concerned about that. So that's a factor right there. The Outer Space Treaty doesn't cover that. So if, say, the US has, Musk wants to go to Mars and settle it and go and basically retire and die there. He is going to have to, but before he can do that, before he can launch a rocket from U.S. soil, he's got to get the permission of the U.S. government to do that. And the government can follow his activities all the way to Mars. And the idea is the U.S. government's got to look and say, look, this wasn't really covered in the Outer Space Treaty. How are our international neighbors going to react to this? I mean, these are things they have to take into consideration before licensing. Is there any national security implications to this? I mean, these are all things that we're going to have to do. And I think one of the big things is, we're going to have to go out and have a discussion with other international states and basically talk to them and say, look, this is what one of our citizens wants to do. We'd like to support it. What do you think? To try and get some sort of, and here's the ugly word of consensus, that, this idea of settlement is not a bad thing. So again, settlement really isn't something that in the current policy environment that's actually considered, both at the Outer Space Treaty and also at the domestic level. I mean, we see space policies come out a lot, but none of them talk about settlement. And really, until national space policies start talking about settlement and Congress starts talking about settlement, it's probably going to be something that isn't going to happen anytime soon.
What, in your opinion, are the biggest 2 or 3 issues facing space commerce right now?
Definitely regulation. I know today there's supposed to be a meeting of the National Space Council, and they probably have this. And from what I understand, they have this big idea on this new regulatory framework, which I really don't know if they have the authority to actually implement. But this is something Commerce is going to look at. How much are we going to be regulated? What's going to be regulated? I mean, are they going to start regulating space debris, saying you have to clean, basically make sure your mess is cleaned up? And actually, industry has taken the initiative on that topic in particular. So the regulatory environment is a big one. Funding finance is a big one. I mean, bottom line is, ever since the Apollo era, when we hear in the Cold War competition with the Soviets, it's been about the government hiring corporations to build government spacecraft, and the money has just been there. Now the paradigm is shifting, where actually the funding is trying to get more into private funding and getting away from government. Although right now, and it's kind of really a tug of war, because we want to break away into this private area, but damn, that money, that private money, that government money is still there, and it's still good and it's lucrative. So we still want to hold on to that. I think a good point is SLS. SLS is purely a government owned rocket as opposed to a privately owned rocket. And you have Elon Musk, who wants to use Starship to actually go to the moon and Mars. But here we have a government in a sense is competing, even though they have more leverage. They are competing with, say, private. And I think the third top one would be public perceptions. I see a really bad public perception, especially since these billionaires have been starting to launch rockets on what I call space tourism, or what I call joy rides. That has how it's really basically this idea of space tourism is stigmatizing commercial space activities, and I think we need to adjust our laws and classify some of these people differently. For example, there was actually a private space mission to the International Space Station last year, and I think there's going to be another one.
There's a second one scheduled, yeah.
Yeah, and basically they're actually going to go up to the ISS. They're going to pay NASA for it, and they're going to do actual research. So really, they're not tourists. So they don't fall into this category as space flight participants. So maybe it's time for Congress to create another category where actually where these people who are performing these functions actually get recognized as what I call non-governmental astronauts, and basically have Congress say, hey, these are non-governmental astronauts, and oh, by the way, we consider them to have the same protections as traditional government astronauts as well, which would be a huge leap forward in international law, in my opinion.
You mentioned the regulations in the last administration. How challenging is the tug of war, to use your term, when the administrations change or when Congress changes? Because obviously the next one might have a completely different thought about what space ought to be.
Yeah, exactly, and that's true. The perception of space and how it should be exploited or used is going to change from administration to administration. I think that's very prominent in national security space. How do we approach national security in outer space? Between the last administration and this administration, it's a very different approach. The same thing with the emphasis on commercial. For example, during the last administration, policy was very heavily weighted in commercial space activities, and science basically took, in my opinion, a second chair to commercial use and exploitation. However, with this administration, the philosophy's changed, with exploration and science coming back on top, and in my opinion, commercial space basically taking a lower tier. So, and this is kind of a side, kind of a detriment, I would say, to our system of government, to our elected system of government, is ideas on how space is going to change. But Congress does have a lot of authority in this, because Congress can basically put down in stone through legislation saying this is the way it should be, and this is the way it should be for the next several years. And even a president is going to have a hard time overturning, a succeeding president is going to have a hard time overturning a dictated Congress, and it's actually going to take an act of Congress to overthrow it. Let me give you an example. The Space Force was put together under the last administration, and a lot of people were hemming and hawing that, oh, this administration is going to arbitrarily kill the Space Force. Well, they can't do that, because only Congress can create a military branch of service, and only Congress can take away that service. The president cannot do that arbitrarily, which gets back to this whole idea of regulations, that Supreme Court case I mentioned, where they basically said, in so many words, federal agencies can't arbitrarily regulate outside of the authority that Congress gives them.
What's the best scenario you see over the next quarter century in space law? And then what's your nightmare scenario?
Best scenario, we get more state focused, what I call bottom-up approaches to international law, where we make rules as we go along and as we learn lessons, we basically make mistakes, and we're going to make mistakes. We start saying, okay, we got to tighten things up here with some rules or guidelines and regulations, and do that at the state level, as opposed to these centralized international bureaucracies. The worst case scenario is this international bureaucracy, and to the point where states actually come in and say, well, we'll give up some of our sovereign authority to this international body, which essentially says we're telling this international body, you have authority over us individual states in certain regards to outer space, which could in some circumstances be unconstitutional, in my opinion, but would definitely create a nightmare situation, because it would really be inconsistent with the Outer Space Treaty.
One more question, Michael, and we ask this of all of our guests to look out, if you might, over the next 10 to 15 years in the realm of space commerce and tell us what you see.
Foggy crystal ball, to be honest with you. I don't know. There's a lot of people, I really don't get into these idea of grand visions of outer space. I mean, one vision is are these things called O'Neill colonies, and people are just so vested in the idea of O'Neill colonies that they're not looking and seeing what's happened and seeing how things are going to unfold. You can move. I mean, it's just like with any goal or any project, you can move in a certain direction with an idea how you think it's going to look, but sometimes it doesn't work out that way, and it turns out totally different. And I think that's why I say I have a foggy crystal ball, just because I don't know how things are going to change geopolitically in the next 10 to 15 years. And it's very hard. And I think from a lawyer standpoint, very imprudent for me to say, this is the way things are going to look in the next 10 to 15 years.
Fair enough. Thank you very much for your time, Michael. I really appreciate it.
Oh, you're welcome. And thank you for inviting me.
That is going to do it for this edition of the Ex Terra Podcast. You can subscribe to the audio version of the podcast on Spotify, Apple Podcasts, and many other popular podcasting platforms. Be sure to click on subscribe so you don't miss an episode of the podcast or any of our other videos. You can also get daily space commerce news at xterrajsc.com. And one thing more, be sure to connect with us on LinkedIn and follow us on Twitter at xterrajsc. Until next time, I'm Tom Patton. Thanks for joining us.